Okay, hello everyone. My name is Ethan Welch. I am a shareholder and attorney at Hickman Lowder, Leader Balk and Welch, and we are presenting these presentations for our special needs clients and their families. And today's presentation is about transitioning. What happens when my child turns 18? There's a lot of questions that come up. Because a lot of benefits are opened up to our children and our family members when they reach that special age. But really, as many people find out, nothing really changes. They're still the child. They're still acting on their behalf, but we just need the legal documents in place in order to make sure that all their benefits are protected and that they are protected, the children are protected. So the outline of this presentation is going to follow this little format that I put together. First, we're going to talk about some vocational assistance and what programs, what entities are out there to help you with this transition, getting that child out into the workforce, or just activities to get them involved in. Then we're going to transition to guardianship and whether guardianship will be really necessary for your child. Then we're going to jump into financial assistance, whether SSI or SSDI is available to this child, especially if that child can't work or they can't work in total, that these programs from Social Security will allow that child to receive some kind of income for the rest of their life. Then I'm going to jump into some special needs estate planning, things that the family, parents, and siblings, and really whoever wants to set aside money for this child, things to consider. And then we're going to talk briefly about planning for more independence. Obviously the child is not going to just move out at age 18 on their own, but we're going to you have to start thinking about that now. We don't want some kind of accident happen and there's no plan in place to who's going to look after my child, who's going to where's this child going to live. So we're going to talk about some options that a lot of our clients look at and and try to do. Try is the ultimate word here. So I'm going to pass this on to our of counsel attorney, Janet Fleck Griffith. But before I do, I just wanted to just touch briefly on this vocational assistance that our governmental entities provide, and that's with the Developmental Disabilities Board and with all opportunities for Ohioans with disabilities. That's the OOD. So these groups work closely with each other. If you're not connected with the DD board, it's encouraged that you do at least get connected with the DD board. You might not receive much assistance while that child is a minor, but getting them acclimated into the board and getting them in there will allow for an easier transition when those benefits do open up, at age 18. So what the Developmental Disabilities Board, many counties have work programs. Some that come to mind is Deepwood in Lake County and Murray Ridge in Lorain County, and the opportunities for Ohioans with disabilities. They do a lot of vocational training so our children will be able to, get jobs and provide opportunities with employers that hire our children. So those are two organizations that really help out in the vocational side. But with more information, I'm going to hand this over to Janet, and Janet is going to go through the IEPs and more vocational assistance.
Thanks, Ethan. So as Ethan said, my name is Janet Fleck Griffith, and I'm of counsel with Hickman Lowder. I primarily work on education cases with Hickman Lowder. So I'm working with our clients that are navigating IEPs, 504s, behavior, discipline stuff, all that stuff that's happening in the K-12 arena, as well as seeking accommodations when students are advancing into higher ed and need some support for disabilities in colleges and grad school. So today I'm going to talk to you guys about transitions from the perspective of your student that's on an IEP in the school setting. And truly, IEP transition planning starts, well before our kids are turning 18. I will echo what Ethan said about getting involved with your county disabilities board. There are so many resources out there. So getting connected with the disabilities board, even if it's, the services are further out on the horizon, I feel like as parents of a child with special needs, our lives are always busy. So the sooner you can get connected to these resources to have them ready before you need them is always prudent when we can manage it, because we're also carting our kids from therapy to school to all the other things. So anyways, in the IEP process, the law says that we have to start talking about transition planning at age 14. And at this point in time, we're going to be mostly focused on the academic component of transition planning. So what sort of courses of study should that student be taking and gravitating towards to support future goals? At age 16, the law requires that we do a purposeful revisit of our transition planning. And the reason why I say purposeful is because transition planning is a part of your IEP document. So truly you should be looking at it every year, but it's at age 16, we're going to take another pause. And at this point, we're going to start thinking about transition services. So before that, you're focused on courses of study. Now you're going to start thinking about transition services. And in doing so, we're going to be inviting agencies outside of the school district to come to the IEP team and participate in the students' future planning and transition planning. And that is because there are lots of resources out there. So your IEP team will grow. And you will sometimes I advise that our clients have like a separate transition planning meeting because it's a lot of information. And you've already got a large school-based team that's really going to be focused on what they're doing here and now. The transition planning team can be a variety of agencies depending on the student's needs. So sometimes it may be fruitful to not try to cram that all into one meeting, but to bifurcate those. So on the right there, you'll see a list of some government organizations that could be looped in to help out. At the very top, I've listed the Child, Family, and Children's First. I think this is an important one to know about because they are actually meant to be like a coordinating point amongst all of these various organizations that are out there. So they can help you coordinate with other agencies. And because they are a coordinator, they can sometimes know about an agency that might be of use to you and your family that you may not know about. So that's an important organization to get involved. And you also work with like the disabilities board or opportunities for Ohioans with disabilities to think about other organizations you should be looping in. Another important thing about IEPs is that your student if your student's on an IEP, they do not need to graduate and phase off of that IEP at age 18 So you're actually entitled to stay on that IEP until the student turns 22. So depending on the student's needs, their trajectory, skills that they still need to build, you may be talking to your IEP team about extending their time to age 22. And part of that benefit is that you get more time to work with the school district and these organizations on building a good foundation for adulthood. And I like to, the first thing I like to point out when I talk to families about staying with the school district until you're 22 is this doesn't mean your student is traversing the high school. They're not going to be like a 20-year-old walking the halls of the high school with a bunch of high school age kids. A lot of times what this looks like is going out to these job placement places or places where they can go to get life skills training, and doing that with the support of the school district. You may also be continuing some services like occupational therapy, speech services, so on and so forth. So it's important to know that that doesn't have to end at 18. The other important thing to know about staying on an IEP until you're 22 is we don't want to ignore these social milestones that are often important to our students. So when you do that, I encourage you to ask the school district for a social graduation. So this is a point in time where your student can walk the stage, take their diploma with their peers. This is often a very special time for students and their families. So I encourage you to inquire about that. And most school teams and school districts are very great about accommodating it. The next thing you need to know is your students getting older. The law also requires that they are involved in some capacity. So for some students, this may look like them coming to the meetings and providing input. For other students, it may not be appropriate for them to attend the meeting, but we will get some information from them, or by we, I mean the school district will get some information from them through assessments. And we'll talk about assessments in a minute. But the student needs to become more involved in the IEP planning process, in their future planning, their transition planning. And this is truly the whole point of this exercise, even from kindergarten to 12th grade, is that we're preparing them for independence and adulthood, right? As much independence as we can give them, and as good of a foundation as possible for adulthood. So we want to involve your student in the appropriate way. And that looks different for every student. Sometimes what I advise clients is that their student should come to the beginning of the meeting and talk to the IEP team, share concerns, interests, things that they want the team to know about them and know about their goals, and then they can go back to class. So that's a good way to balance student participation, but also leaving time for the parents and the school team to be able to talk openly about the students' needs. We always want to be sensitive to how we discuss that in front of the student. So student involvement becomes an important component. And then the next bullet point there is the agency invitation. So I already talked about you're going to have agencies coming in. The parents have to sign off on that. So you want to make sure you're signing something that says that identifies which agencies are coming. The next bullet point, current abilities, so to future goals. So the point of transition planning is to look at the student's goals and look at their current abilities and figure out what needs to happen in between to get that student from their current abilities to their future goals. This should be, I think sometimes you're so focused on the here and now, which is what your student is doing in school right now, the goals that they're working on, are they getting enough OT minutes, that we can gloss over transition planning. But really, it should be a purposeful, well thought out process, because that bridge from current abilities to future goals, that bridge from adolescence to adulthood, there's lots of supports and there's lots of things that can happen in that time. So we want to take a good moment to look at it. The last point I have here is about fading accommodations and services. So one of the things that I'm always cognizant of when I'm working with our clients, whether they are in 2nd grade or 10th grade, is what accommodations we are using to support them and what those accommodations will look like as an adult in the real life. in the real world. So a good example is chunking is something we do all the time for students with executive functioning needs and ADHD. For those of you who don't know what chunking is, it's when you take a large assignment, like a teacher might give the class a big project assignment. And instead of just handing it to them in this global way, the teacher will chunk it out and give it to them in phases and help walk them through those phases. One of the things we work on while that student progresses through their grade levels is how do we teach them to do that themselves. And so what we call that is we're fading those accommodations. So when appropriate, we want to start fading so that they're ready for that transition to adulthood. But we also want to make sure that we're not fading before they have the skill set to do something independently. So that's an important balance and something you work on with your IEP team. Okay, so this is how we tackle transition planning. So the first part and most important aspect of transition planning is the age-appropriate transition assessments. And this is how we identify where this kiddo's headed, right? So there are lots of assessments out there. So you want to touch base with your IEP team and understand which assessments are appropriate based on the kids' needs and their interests and sort of where they are in their schooling journey. But you're going to use these assessments to identify preferences, interests, needs, and strengths. And those assessments then become the basis for your post-secondary goals. Once you've completed the age-appropriate transition assessments, the team will come up with some post-secondary goals. So these are different than your typical IEP goals because they're not goals that, like an IEP goal for reading, you're working on that every day, right? Very purposely at that goal. Post-secondary goals are like what the student aspires to do once they graduate. And what we're going to do is help them build the skills to reach those goals post-graduation. So if you look under where it says post-secondary goals, these goals are based on the age-appropriate transition assessments. They focus on what the student will do after high school. And the goals must cover 3 things: education, training, employment, and then a fourth, if the assessments deem it necessary, independent living. So this is one of the reasons why I say it's critical to consider whether it's appropriate to keep your student on that IEP until age 22, because they're going to be getting that support on education, training, employment, and independent living. Over on the right, you'll see some common assessments that can be completed. I love interest surveys. It's one of the simpler assessments, but it really is a nice moment to think about what the student likes doing and how that could translate to a career path. I also encourage some of these assessments to be repeated because what a 9th grader thinks they want to do can be much different than what an 11th grader thinks they should do. So don't ever be afraid to ask your school team about repeating an assessment to get some updates on their interest, where they are with daily living skills. It's totally appropriate to repeat them. So the next 2 slides I'm not going to spend a lot of time on, but I always like to put the documents in front of you when I can. Much about the IEP and special education process can be very confusing and unknown. So sometimes just being able to see the document is helpful, but this is part of the transition planning portion of the IEP. So it's the section that's identified as post-secondary transition. And in there, you'll see the first section is covering training and education. And that's where you'll see the measurable post-secondary goal. And right below that, the reference to those assessments that we've been talking about. All right, and then this is the section that would cover independent living. And again, very similar, you're going to see that reference to the post-secondary goal and the assessments. And then I'll go to the next slide. Thanks, Ethan. And then this is a blip from the competitive integrative employment section of the IEP. So a couple of things that are important to know. you look at these every year, right? So I already talked about how age 14 and age 16 are specific milestones, but this is part of your annual review of your IEP. The other thing that's important to know is we're talking about competitive and integrated employment. That is the purpose of our transition planning. So when we look at this historically, it used to be that the assumption was that the student would only be able to attain sort of a lower level goal related to employment. The law has shifted that and has put a requirement on us to start with the concept of competitive integrated employment. So we want to be finding places where this student can be working alongside the general population, right? Sort of similar to that least restrictive environment concept that we're employing in the K-12 setting. So we want to find job places where they can be integrated with typically developing peers and also be offered competitive salaries. So too often we were finding that students and individuals with special needs were being put in sort of these like work camps where they were with other folks with special needs. They were, underpaid. And this is meant to sort of reshape that conversation. So we're really looking at giving them competitive wages, integrated employment. So I will just, I like to add in a personal note because this is why I do this work. So this is my brother, Edward, and he works at Disney in Florida. And this is why I love doing this work, but this is also why that competitive integrative employment is so important, because it was not a focus when he was younger in life. And it has been a very difficult journey for him. He has found employment that is competitive and integrated, and he loves it, but there were a lot of bumps along the road. So setting the IEP up in a good way can hopefully get you to competitive integrated employment sooner. Should you decide based on your students' needs that might not be their landscape, then there's other options too. It's all about having the
Okay, it looks like that we lost Janet. But that's okay. She was almost finished with her presentation here. Her next slide was about post-secondary education.
Yes.
Are you there, Janet? Okay, great.
Yeah. Okay, sorry. Guys, I'm coming to you live from the Transition Expo in Independence. So it's all about transitions today. And I can assure you there is a room full of resources out there. My internet connection might be a little spotty, but this is my last slide. So here I just wanted to touch on post-secondary education and some of the variables you'll be thinking about related to that. So it's important to know that when your student's on an IEP, they are covered by the IDEA. Once they are out of the IEP age range, the IDEA no longer applies. Then we will shift to the Rehabilitation Act, which is the act that governs 504s. And that's how you will seek out accommodations in college. So some things you'll want to think about when if your student's planning for college or vocational school, are there any tests that they need to take, like ACTs, SATs? You will want to apply for accommodations for those tests. Similar when you get to college, you will want to reach out to someone that can help students with accommodations. Typically, they end up with something that's called an individualized service plan. So you go from like IEP to ISP, sort of the same thing. And we like to give our clients like a couple of pointers about colleges. You'll want to think about things like the city size and navigating the city, sports, arts, extracurriculars. Like we can get pretty focused on academics, but we want to make sure like those social institutions are in place and that your student has a good way to access them. And then thinking about school visits. So locally, we often tell people to check out Notre Dame and Kent. Notre Dame, I know, has a really great support system for students with special needs. And they actually have a summer camp called Thrive that helps students get ready for entering college. You'll be talking with your student and your IEP team about whether or not vocational or technical school may be their track of choice. And then the last thing is the exit IEP meeting and the yellow box at the bottom, the summary of performance. So what happens here is you want to have like a capstone conversation with your IEP team and understand where that student is now, which accommodations they're accessing and using frequently. Maybe there's some accommodations that they haven't been using that much, and that's helpful information as well. So the summary of performance is going to give you the summary of their academic achievement, the summary of their functional performance, and guidance on accommodations and supports that may be helpful in post-secondary life. So this is a really great document to take with you when you're taking that student to vocational school, technical school, college, the workplace, because the Rehabilitation Act is applicable in the workplace as well. So that's an important document. It's important that it's accurate and you've got good feedback from your school team on it, and that you have it handy when you're looking for accommodations outside of the K-12 school setting. And that's all I've got.
Awesome. Thanks, Janet. Okay, so we are now going to transitions the buzzword today, to guardianship and whether, guardianship is really necessary. So I'm going to, many of you probably already know a little bit about guardianship, or maybe a lot about guardianship. I'm going to take the position that you know nothing about guardianship. And so we're going to review, what a guardianship is, how to get guardianship, and then we'll talk about, okay, what are ways to avoid a guardianship. So first we have to understand, oh, Janet, go ahead.
Yeah, no, sorry to interrupt. I realized I forgot maybe one of the most important points, and then I've got to go. Yeah. I've got to go back to my transition expo. But you said guardianship, and I should point out that once your student turns 18, they are actually the person that signs their IEP, unless you have something else in place. That is a good segue to guardianship. So I won't interrupt anymore, Ethan.
No,
Thank you.
No, that was perfect, because you either have to, if your child can't speak up for themselves, or they are vulnerable and you don't want them to speak for themselves just yet, well, that's where a guardianship would come into play, or maybe a power of attorney. So we'll get into both of those right now. So the first thing to know about guardianship is the terms. What are we talking about here? So a guardian is the person that the court appoints to look after this ward. So the ward is actually the person that needs a guardian. So we've got the guardian over the ward. The ward is the disabled person. Incompetence is a legal term, meaning that the court has deemed that this person is impaired or disabled by various ways, whether from birth, whether from an accident, whether from chronic substance abuse, that they cannot take care of themselves, that they can't take care of themselves as a person, or their property, or their finances, and they can't meet their legal obligations. So the court needs to appoint the guardian over the ward. Then I threw in this capacity term. You might hear capacity and incompetence thrown around together. Totally different terms. Incompetence is a legal order from the court, and capacity is determined by doctors, by lawyers, by social workers, by healthcare providers, that this person can't make a decision now. Think of, if you're in a coma, you don't have capacity to make a decision. You don't have the capacity to even talk at that point. So capacity can come and go. Another, another example is dementia or Alzheimer's with our elderly population. You've heard of sundowning, where in the morning our loved one seems pretty normal. She seems pretty with it, that she can recall things, and she does what she loves doing. But as the day gets going, you start to see the effects of her dementia. So capacity comes in and out, even daily, weekly, or even hourly for that matter. The capacity comes and go, and competence lasts. So the requirements of getting a guardianship is what the court will determine is the ward incompetent? Is there a legal standard that this ward is incompetent? Is the guardianship necessary? Does this guardian need someone to act on their legal behalf? Is there any other less intrusive means to get this taken care of for this ward? And what we'll talk about later is, is there a power of attorney that might be able to do the job? The reasons why we need a guardianship, managing funds and property, the financial side of things. And the property is, bank accounts, it can be real property, it can be vehicles. Does a guardian need to look after these items and this property for the ward? And then we have the medical side of things and the placement where this person's going to live, and the programming and education side. Does this ward need help with finding an appropriate job or education that they can't find themselves? So these are the types of guardians that are appointed by the court. Well, not necessarily all by the court, because we have the natural guardian, and the natural guardian is a parent from age 0 to age 17. So once you are, become a parent, whether through birth or through adoption, you are that natural guardian of that child. Once that person turns age 18, now they are considered an adult under the law. And now we have these terms from the probate court and from the Ohio Revised Code that come into play. So now we have the guardian of person and guardian of the estate. Those are the two most common types of guardianships, and it's the most broad types of guardian. So guardian of person deals with the healthcare and medical side of things, and placement and education and programming. And the guardian of the estate deals with the finances and real property and personal property of the ward, managing their financial affairs. So that those two people usually are the same person. They don't necessarily have to be the same person. And we'll get into reasons why they might not be the same person. To be a guardian of the estate, generally the estate should be more than $25,000. That's the general case. That's what the Ohio Revised Code says. But it can be less if the ward has more than $25,000 and then they drop down below $25,000. You can petition the court to terminate the guardian of the estate due to lack of funds. So that happens occasionally. Then we have these less common terms of guardianships, and those are a limited guardian, interim guardian, and emergency guardian. So you could ask the court to become guardian for a limited time, or a limited purpose, limited purpose, or an interim time. That, I want to become guardian, just for the 6 months, so I can get him into a proper group home. Sure, you can ask the court for a limited time or a limited purpose or an interim time, but more than likely, if you ask that for the court's going to say, well, I understand that you want it for this limited time or a limited purpose, but they need a guardian full time. So we're going to appoint you as guardian full time. So it's very rare to have a guardian for these limited, times and purposes, but for whatever scenario, it could be a possibility. Then we have the emergency guardian, and that emergency guardianship is very rare to get. The emergency, many people think that, hey, if something happens to me, then that's an emergency that someone needs to be appointed right away. And an emergency guardianship is a very specific procedure with the probate court through the Ohio Revised Code that says, yeah, we're going to appoint someone right now, today, to become your guardian, and there won't be a hearing, and there won't be a extensive review over whether this person should become guardian. That scenario, though, is very rare. Essentially, you need a doctor to fill out a form, an extensive form above the form that they would normally sign for a typical guardianship, that says that this person it's an emergency, their life is in the balance, or their funds are going to be taken away, and they need to be appointed right away, today. Many doctors aren't going to sign that and fill that out. And I've heard from social workers, from hospital staff, that essentially that this person needs to be bleeding out and on their deathbed if they don't get this procedure right away and get authority from an emergency guardian to perform that procedure. Every case is different, of course, but an emergency guardianship application is never a slam dunk. It needs to be extraordinary circumstances for an emergency guardianship to come into play. So I've talked about this guardian, and who is this guardian? Well, here's the basics of who this guardian could or should be. Obviously, they have to be over 18. They have to be an adult themselves, and they have to be competent. The guardian of person, no residency in the state of Ohio is required. So you could be living out of state, or in many people's scenarios, that a sibling lives out of state, live in Florida or California. They can become guardian of person over their sibling that lives in Cleveland. We have many clients that do that. Guardian of the estate, though, the resident of the state is, in general, is required, unless the person is named in another document to nominate this person that lives out of state to become the guardian. But even if that's the case, many courts will decide, no, we need the person to live in Ohio. The reason why there's a difference between a guardian of person and guardian of the estate requirement, residency requirement, is they want to make sure that they can sue the guardian of the estate in Ohio court if they steal money or are reckless with money, where they can get that money back. So the person must be bonded. If they want to be a guardian of the estate, they must be bonded by an insurance company, and that basically is an insurance policy is placed over this guardian of the estate of twice the personal property, twice of the amount of the personal property that the ward owns. So if the ward owns $100,000, an insurance policy of $200,000 would be placed on that guardian of the estate and that's an extra, obviously it's an insurance policy, it's extra insurance that this person, if they do steal money, that the insurance company will then pay out to the ward with that money, for that money that was stolen. So a $200,000 bond, that could be, a few $100s from an insurance company premium. So that's what you would pay annually to the insurance company to be bonded. And that money is typically paid from the ward's money. So in general, an agency can't be a guardian. It's typically an individual that's appointed as a guardian. And obviously the guardian must not be convicted of these offenses because the court wants a suitable person to be the guardian. So I touched on this, nomination of guardian, that the parent may appoint a guardian of minor in a will, and a nomination of guardian for an adult can be in a will, but it's not always sufficient. So we would recommend a separate document, or even in a power of attorney, the parent's power of attorney, they would nominate someone else to become the guardian. So we like to put them in most of our documents, just to, here's the fact, court, they put it in all three of these documents that they wanted this person to be the next guardian. And that's exactly what a nomination is. A nomination is simply the person nominating to the court who they believe should be the next guardian. The court is the ultimate decider of who should be the guardian. So even though you nominate someone, the court takes that with great weight, but once again, it's not a slam dunk that the court's going to follow your wishes, especially if they determine, yeah, this person isn't as great as, the parent made them seem, because of, X, Y, or Z reasons. And that this other person, this other family member, seems a little more suitable to become the guardian. So I mentioned this, the out-of-state guardian of the estate, the court may appoint if nominated in these documents, but that's the key word there is may. The court has the authority to determine whether this is appropriate or suitable or not to appoint this person that lives out of state to manage the money in Ohio. So the procedure of the application for a guardian, I gave this the Supreme Court website resource forms. There is a whole list of forms here, but essentially what you need to do to apply for a guardianship are very basic forms. It's the application for guardianship, which is a 2-page form, very simple, that fills out who the ward is, who you are, and what you're asking for. What are you applying for? And that's where that guardian of person, guardian of state, limited, interim, all of that is on that form. And it asks you, hey, have you been convicted of any crimes? Kind of a little bit more, they want more information about you in the application. Courts, there's a lot of courts have a lot of nuances. I know Summit County, Lorain County, they have extra forms for the application to fill out, to dive in more detail about the ward and about the applicant. But every county is different. So all 88 counties have different rules. So you just have to figure that out with the local rules, or have your attorney figure that out. Then we have the next of kin form, which is another very basic form that lists who are the next of kin of this ward. So that doesn't mean that you have to list out all of all of the nieces and nephews, all of the cousins. No, that just means the next in line of consanguinity, which is if this is your child, you would list, the parents and their siblings. If there's no parents, then just the siblings. If there's no siblings, then you would list the nieces and nephews. You just go down the list of who are the closest living relatives to this ward, and that's what is listed on the next of kin. I missed the point here. And, the reason why you do that is the other family members have the right to contest and file a competing application. So if a sibling says, no, mom and dad wanted me to become the guardian, so I'm going to apply, and another sibling, because another sibling had applied, in that kind of scenario. So continuing then, so you got the application filled out, you've got you've got the doctor's opinion. So I didn't mention that. We need a doctor's opinion called a statement of expert evaluation. And you've got the next of kin, and that's filed with the court. So that's filed. The court will then set a hearing date 4 to 6 weeks in advance. The reason why there's a delay in the hearing is so a court investigator will come out to meet with the ward and explain the rights of the ward, that the ward has the right to contest, has the right to bring witnesses, has the right to an independent evaluation, and the investigator will then tell the ward, here's the hearing date. And this investigation will need to be done at least 7 days prior to the hearing. So with that being said, then, if we're talking about a typical transition case, I really am hardly concerned that the ward will contest, but it's always an option to consider when you explain to your child, what's happening. Many times they don't really understand, or they're okay with it. So that's been my experience. It's been very rare that a child would contest, especially with this transition guardianship. So here are those hearing rights of potential ward. The hearing right, as I kind of already explained this, that they have a right to have their family and friends present, and they have a right to present evidence and cross-examine. So if they, meaning cross-examining, meaning if you have a witness, then the ward can also cross-examine that witness. They can rebut that witness. And if they have a decision that they are, against, then they have a right to appeal, and they can ask for the transcript of the appeal, and the court will provide that expense if they are considered indigent. So if you notice the correlation between these rules, it's very much like an indigent criminal defendant, where they have certain rights. Well, so do wards, and that really, if you think about the reason why all of these rights are protected, is think of what happened 50 years ago and beyond, with people with disabilities. They weren't afforded these rights, and they were locked away, and they would never see the outside world again. So these rights really are great, because it would be scary to see a world without them. So that the actual hearing procedure. So we made it past the investigation phase, and we came to the hearing. Depending on the county, it could be in front of a magistrate, it could be in front of a judge. The guardian must prove all of these elements, that the person's incompetent, that there's a need for the guardian, there's no less restrictive alternative, and that the person is suitable to become guardian. And there must be clear and convincing evidence of this. So what's clear and convincing evidence? I love this little chart here that you're looking at beyond a reasonable doubt. That's in a criminal case that you are almost 100% certain, or you are 100% certain that this person committed this crime. And then you have at the very low end of this, the spectrum, where someone's just been arrested, that there's suspicion, and then you have probable cause. And then probable cause meaning, yeah, this person more than likely committed this crime. We're going to charge them with this crime. And then you have preponderance of the evidence. That is on the civil side of things, where in a lawsuit for medical malpractice, let's say, there is more than a 50% probability that this person committed medical malpractice, and the case should be decided in favor of the plaintiff. So you see clear and convincing evidence. It's somewhere in between beyond reasonable doubt and preponderance of the evidence. So you're saying that, yes, given the totality of the circumstances and all the evidence, that this person needs a guardian. That's what clear and convincing evidence. That's what the judge in the court is trying to determine. So special considerations with the guardianship that many people don't really know is, just because you are now considered an incompetent and you're a ward, that doesn't mean that you can't vote. It doesn't mean that you can't drive. You can get a driver's license if you're able to, and you can vote if you're able to. You can get married, but you would need the court permission and the guardian approval before the court will issue a marriage license, or a marriage certificate. So once that person is married, then the guardian of person terminates upon the marriage. Because if you think about that, the spouse is now responsible for their spouse. And note that the guardian of your estate does not terminate. So if there's money involved, the guardian of the estate will continue on. Wills will need court, before a will can be signed and effectuated, the court needs to approve the will and approve that this person does understand what they're signing. So if a guardianship has been established, and then the person dies, and then a will is found, the will would only be valid if it was made prior to the guardianship. And even then it would be hard to get that admitted to the probate court as a valid will. So wills need to be presented to the court and approved by the court if it's done after the guardianship has been established. So some nuances, there's obviously, once you're a guardian, you're always going to be reviewed by the court. You're not going to be forgotten about. There's post-appointment reviews that can be done every 2 years or by request of the ward. Anyone can file a motion to review the case, including the court, to review whether the actions of the guardian, review the actions of the ward, and then anyone can file a complaint to the court, a complaint or a comment on the guardian's work. So if the court then deems that complaint serious enough, they will then have a hearing. And all of this is by local rule. So every county has different nuances to it, but there are ways that family members aren't just out in the cold. They can review the case. They can ask the court to review the guardian's actions. So always remember then that the probate court is the superior guardian. So the court can always remove and replace the guardian if they don't deem this guardian acting appropriately. And with that being said, if something does happen to the guardian and a ward is, needs a medical procedure, there's an emergency, and there's really no one involved to become the emergency guardian, the court will issue an order in order to protect the best interest of the ward, to make sure that a medical procedure is being done and the ward is protected. So after you're appointed as guardian, there's obviously duties that you have to comply with. You have to file annual or every 2 years reports with the court. That is a report of what's happened the last year and a plan of what's going to, what's the future going to entail with the ward. And then there's mandated training that many counties require. There's a 6-hour course initially, and then every year thereafter, there's a 3-hour course. And those are presented by the Ohio Supreme Court, or the local county courts issue these training modules too. If you or the ward change addresses, you have to give notice to the court. The change of address for the ward is only notice if it's not more restrictive. In my experience, we notify the court no matter what. If there are legal papers of the ward prior to that ward becoming disabled, you have to present that to the court. And just very drastic changes of the ward status, you need to report that to the court as well. Continuing with the guardianship duties, if there are complaints, well, the guardian can't just put their head in the sand here. They have to act on that and make sure that the ward is being heard and responding to. And if the guardian does see abuse or neglect on the part of a group home or facility or who they're living with, they are mandated reporters, and they have to report that to the police or adult protective services. And then finally, representative payee. So representative payee is an office of the Social Security Administration. The Social Security Administration, they recognize a guardian, and typically they would appoint the guardian as the representative payee. But if the guardian chooses someone else to become representative payee, that's totally fine. A guardian, a person, can apply to become the rep payee. So even though you're guardian a person, you can still manage the Social Security income and account of that person as long as that account is below $25,000. The Social Security then is not reported to the court because the Social Security Administration administers and oversees this money. So what I typically see is, if we have the parents of a child who's just turning the age 18, one parent might say, I will become guardian of person, and why don't you become representative payee, because you're better with money, and that way we're divvying out the responsibilities here. And that's totally fine. It's totally fine having one parent in control of everything. It all depends on the family circumstance. Okay, we got some slides that were redundant. Then we have the termination or removal of a guardian. So I pointed this out that, if the ward is no longer incompetent, which happens, very rare, but if the person is no longer incompetent, the statement of expert evaluation or a new statement of expert evaluation can be filed and the guardianship will be terminated. If a guardian resigns or dies, a new person will have to apply to become the guardian, and a new guardian is then appointed. If the guardian is removed by the court for good reason, and it has to be a very good reason, and it has to be for the best interest of the ward. It can't be just because the family or the ward doesn't like the guardian. They just don't like them. We want them removed. Well, the court's going to say, well, no, are you being, how is your livelihood? How are you living? Just because you don't like what the guardian is saying to you doesn't mean that that is in your best interest to have this person removed, because you are being taken care of. So it has to be for the best interest of the ward for the guardian to be removed. So with all that being said, obviously there's a lot to do with a guardianship. So a guardianship is time consuming. It is costly. There's court fees, there might be attorney fees involved, and we have the public knowledge of what's going on. This is all public record. And most probate courts are now having an online docket where you can review, 90% of the documents that are filed, and you can see the drama, or, if there's no drama, you can just see everything that's going on. The only thing that isn't available, which can be made available, are medical documents or sensitive financial information that's filed with the court. But there's ways to get around that people can access. So for those reasons, we want to try to avoid a guardianship if all possible. If the person is able to generally understand a power of attorney and sign their name to a power of attorney, then I would recommend let's try the power of attorney first and see how that goes. So generally understand, what I say is, can I tell the child, hey, mom and dad want to be able to help you talk to a doctor, talk to the bank on your behalf and with you, because that's exactly what a power of attorney is. Power of attorney is, it's a helpful tool to aid the principal, the person that's signing the document. If they can understand that, and we can go in, the nuances of the power of attorney then, but if they can understand that, then yeah, they can sign this power of attorney. They have the capacity to sign it. And these are the documents that we draft: a healthcare power of attorney, a financial power of attorney. And I realized I didn't include it in this slide, but we also do an educational power of attorney. So the parent or whoever is appointed can still speak to the school district and be a part of the IEP meeting, because we know horror stories, and we've seen horror stories that the school districts, they do an IEP meeting without the involvement of the parent, because now that child is age 18 and they kind of, spring it on that child. So the power of attorney will be able to get in there and get into that meeting, get a new meeting established. We also do advanced directives for end of life care. You can do that, not really necessary. The big documents here are for the powers of attorney. These powers of attorney, though, are revocable. They can be revoked verbally, in writing. So that's the thing with a guardianship. It's more permanent. then you can't revoke it. We see a lot of problems. I typically don't see that with a transition child, you know, a disabled minor child becoming age 18. Where we really see that is with our mental health clients, where we would have to input some mental health directives. So the reason for that is, you know, if a child is, you know, signs a POA and then they have some kind of psychotic break where they become institutionalized, and they tell the doctor to don't talk to my parents, don't talk to whoever is my agent. The doctor has to follow the wishes because there's never been a court order deeming this person incompetent. So at that point in time, if you don't have a mental health directive, then the only option is to apply for guardianship. And just because they are refusing to talk to the doctor doesn't mean that the financial power of attorney is null and void, as long as that's not been revoked. But that's really your only option if you're in this special scenario where they're telling the doctor to refuse to talk to mom or dad or my agent under my power of attorney. So that's guardianship. Those are ways to avoid guardianship. Now we're going to transition now to SSI, so supplemental security income. Typically, when a minor child is a disabled minor child, they do not receive SSI, and that reason is because parents' income and assets deem to the minor child. So whatever mom or dad has, they have. The SSI benefit is capped at a certain amount. In 2023, it's capped at $914 a month for a single person. Once that child turns age 18 and they medically qualify, they're deemed disabled by Social Security, and their assets are below $2,000 and they have a very limited income or no income, they will qualify for SSI. So typically what I tell clients is you should start applying, you know, a month or two before the child turns age 18. That way you get the applications process started. And by the time that the child turns 18, SSI will be eligible for the child, and they will receive the first check, you know, shortly thereafter. There are, you know, there's a lot of nuances with SSI, and for a lot of clients, it becomes a pain in the butt to administer. But having SSI as soon as possible opens up a lot of doors of benefits for clients, for children down the road. But essentially what SSI is intended for is to pay for beneficiaries' food and shelter expenses. So that, you know, that kind of is counterintuitive when this beneficiary is also living at home, receiving free food and shelter by living at home, being over age 18. That will reduce the amount of SSI this child receives. So what we do to counteract that is we utilize room and board agreements. And that's basically a rental agreement that this child pays mom and dad, you know, X number of dollars a month in rent for the room and board. And that money now becomes mom and dad's money. They can do whatever they want with that money, setting it aside for the beneficiary in a separate account, or under their name, the parent's name, or, you know, using it for food and shelter expenses. So, someone had a comment that SSI told me it is $2,000 per parent for a married couple. I'm not really sure what you mean by that. It's for a married couple. If they have more than $3,000, their child won't receive SSI because their assets deemed to that minor child. If what I meant by these accountable resources is this unmarried person, this child who's now age 18, they have to have less than $2,000. If that child is now married, between their spouse, they have to have less than $3,000 combined in order to still receive SSI. Okay, so you're referring to a minor. You can't have more than $2,000 deposited in your account per parent. No, it's $2,000 in total. So it doesn't matter. You can have 5 accounts, but those accounts have to be combined less than $2,000. There's exemptions to that, and if you go to we've done Social Security and benefits in a prior presentation. So if you go to our website, it's the ABCs of benefits. So go back to that slide, that presentation, and we dive a little bit more into Social Security and SSI. Another question: is there a recommended amount to charge for the agreement? There is. You take the household expenses of rent, mortgage, utilities, insurance, real estate taxes. And when I mean utilities, I mean the shelter utilities. So gas, electric, trash, those utilities keep the roof over the head. Not cable, not internet, not phone. But you take those utilities and those expenses and the food expenses of the household. You take, and that is eating out with takeout or groceries. You take the monthly aggregate of those expenses and then divide by the number of people that live in the household, and that is the beneficiary's rent amount. And that might be over $900, let's say. And that's okay, because the room and board agreement should state that if there's more money owed, then the beneficiary receives more money from another source or from a back payment from Social Security, then that should be paid to the parent as a back payment for rent. So that should be incorporated in the room and board agreement. So a little bit more on SSI eligibility. Obviously, you must be determined disabled under Social Security rules. Unless you're over the age of 65. So if you had no income, you are eligible for SSI over the age of 65. You have to have a monthly countable income under the applicable benefit amount, which is $914 a month. But there's certain nuances and a weird formula that they use, that they subtract the first $20 of monthly unearned income, the first $65 of earned income, and then 1/2 remaining of the earned income are excluded. So you might be making $1,000 a month, but if you go through this formula, let's just, for ease of math here, let's just say it's $400 that's countable. That will reduce your SSI by $400, so you'll receive $514 a month in SSI. But there's other, you have to incorporate all of your monthly, income. And SSI looks at income very broadly. So that's any money essentially that enters this child's account is deemed income. So it's not taxable income. It might be just $20 that you put in their account for whatever reason, or it's a birthday gift and they receive $500 from birthday gifts in cash that's deposited in their account. That's considered income. So it's a very broad definition. And like I said, the free food and shelter, that's considered in-kind support. It's from whatever source, whether you're living with this parent or the parent is paying rent, you're receiving free food and shelter. That will reduce the SSI payment by 1/3. So if you're living with the parent, once again, you just use the room and board agreement to increase that SSI payment so we don't get that 1/3 reduction. So the countable resources are below $2,000 at the end of the month. So someone might receive $5,000 and that might jeopardize the Social Security payment that month, because the $5,000 is not considered an asset, it's considered an income. And for that month, you receive $5,000, that is income. For that month, you technically shouldn't receive SSI, but you already did. So the next month, they'll say, hey, we can't pay you because you received this money. But if you still have that $5,000 in your account at the end of the month, that income now is considered an asset. So if you receive money, you have to spend that money, or you have to put it in a special needs trust or a stable account, and we'll get into that in a little bit. But essentially, you have to get rid of that money at the end of the month before that money becomes an asset for the following month. And because we want to make sure that benefits are only affected for that 1 month. So SSI recipients are categorically eligible for Medicaid. So once you receive SSI, you receive, you're eligible for Medicaid. Medicaid is the insurance. And if we're talking a transition for children, this means that more than likely they might still be on parents' insurance. Well, that's totally fine, and you can continue to be on parents' insurance. Medicaid will just be the secondary insurance and pay for any medical expenses that the primary insurance doesn't pay for. So then the other aspect of this is SSDI, and really I'm going to go over SSDI very quickly because for transition planning, SSDI doesn't really come into play, because to receive SSDI, which stands for Social Security Disability Insurance, the person has to have enough work credits in order to qualify. So you have to have at least 10 years worth of work credits and to be eligible for some benefit. And there's another way to receive SSDI, but there's certain things that make SSDI much more appealable to people. There's less reporting requirements to Social Security. There's no asset limit. So I mean, anyone can be approved for SSDI, and they can have money in the bank. They can have $1 million in the bank and still qualify for SSDI if you have enough work credits. The monthly benefit is much higher than SSI. It's based on the average lifetime earnings. So the payments then should begin 5 months after approval. And after 24 months after approval, the person is eligible for Medicare. But this is important for everyone, and it goes back to why getting eligibility for SSI is important. It's if this child is disabled before the age of 22 and the parent retires themselves, they start receiving Social Security benefits, the parent becomes disabled and is receiving SSDI benefits, or the parent dies, then that disabled adult child, the DAC child, will then be eligible for SSDI based off their parents' work history. So that's 50% of their parents' benefit while that parent is alive, and it's 75% at that parent's death. And you can only choose one parent, and it's always the higher earning parent that you choose. And then Medicare eligibility is also available to this DAC child after a 2-year, 24-month probationary period. And because they're a DAC child, there is a special nuance in the rule that says, hey, because you're receiving more money and typically you wouldn't qualify for Medicaid, we're still going to give you Medicaid because you're grandfathered in. You're an exception to the rule. So essentially, this child can receive a higher income with SSDI. They can be on Medicare as the primary and Medicaid as a secondary, covering all of Medicare's out-of-pocket expenses. So it just opens up a lot more doors for this child. But if let's just say that the parent never gets around to getting a disability declaration by Social Security before the age of 22, that's okay. If this child has been, disabled since birth or disabled since a very young age, and you have the medical records to account for that, then you can get a disability declaration before the age of 22, so that child is a DAC child. It just makes it a lot easier and a lot cleaner if that child is receiving SSI before the age of 22. Well, you automatically have that declaration that this child is disabled before the age of 22. So SSDI, a lot easier to work with, a lot better in general than SSI, because more money, less reporting, and the Medicare eligibility on top of the Medicaid. All right. So we talked about vocational assistance. Now I wanted to segue to special needs estate planning, because this is what I would, and we already talked about this in prior presentations, but I wanted to touch on this again because this is just another phase of transition planning. And we might have to utilize some of these accounts, such as a special needs trust or a stable account, in order to get this child qualified for SSI. So to be eligible for Medicaid, a Medicaid waiver with the DD board, SSI, the child must be below $2,000 in assets at age 18. The Medicaid waiver, just so we're all on the same page, a child below age 18 can still qualify for a Medicaid waiver, even though their parents might have money and they might have income. So that Medicaid waiver, the waiver means, the first meaning of a Medicaid waiver is you are waiving the requirement that this child needs to be institutionalized, that they need to go to a facility or an intermediary care facility, an ICF or a nursing home, that you are giving Medicaid benefits in the community so that child can be a part of the community. That's what they're waiving that institutionalized criteria. the waiver also means if the child is deemed, having a severe disability before the age of 18, that they're waiving that financial requirement of that less than $2,000. So that's why some children and some families receive a Medicaid waiver being below age 18, because that deeming requirement has been waived. But once that child turns age 18, now every organization is looking at that child specifically to determine, does this child have less than $2,000 in assets to qualify for these programs? And if they do, that's great, they qualify. If they have accounts, then we have to do something with this money. We either have to spend it down, or we have to just put this money aside in these special accounts, the special needs trust or a stable account. So I typically would advise a client, if we're talking about $10,000, $15,000, even $20,000 for that matter, we could utilize a stable account to just put this money in that account. It's free to open. It's managed by the Ohio Secretary of Treasurer's office, and just put this money in this account and use it as a savings account. And once again, we talked about these accounts and special needs trusts in a prior presentation, but this is, I'm just giving just an overview of these accounts. If we're talking about, our child received this big inheritance years ago, and it's in this account, and it's $50,000. Well, you can't put that in a stable account because you can only put up to $17,000 per year in a stable account. So you have to utilize a special needs trust to put that $50,000 to protect it. The drawback of using a stable account or a special needs trust, there are Medicaid payback provisions at this child's death, that if there's any money in this account and the Medicaid has given benefits to this child throughout their lifetime, that money that's left in this trust account is paid back to the state of Ohio for a Medicaid reimbursement. So you use this money while this child is alive. You don't waste the money, of course, but you utilize this money because there is a Medicaid payback. But this is the only way to legally and validly and properly transfer money in order to get on benefits. You can transfer money to parent, to a charity, to sibling, but that's perfectly legal. That's a proper gift, except that for Medicaid purposes, that's an improper transfer, because you cannot transfer money in order to get on Medicaid and get on SSI. You need to properly transfer that money, and the way to only properly transfer that money is with a special needs trust or a stable account. So these are called first party accounts, first party trust, and a stable account, first party, because that is the individual's own money, the child's own money that you have to then set aside in order to retain benefits. But for estate planning purposes, we would never recommend that kind of trust. We would use a third-party trust, a wholly discretionary trust. It's administered very much the same. The huge difference is there is no Medicaid payback provision in this trust. The reason why is the beneficiary never had any legal ownership or control over this money. So parent, it doesn't have to be a parent, it could be anyone for that matter. It can be grandparent, it could be me. I could set aside money for anyone. in this wholly discretionary trust, you are setting aside money for the benefit of the child, for the beneficiary. And they never have legal ownership over legal control or possession of this money. They're just the beneficiary of this money. The trustee that you appoint to manage this money, they're in control. They have the ownership. They manage this money for the benefit of the beneficiary. They use this money. If they need something paid, they pay it to that third party provider, or that third party creditor, that third party vendor. They never pay money directly to that beneficiary because, as I said before, Social Security has very strange rules about income, that any money that comes in, that will be considered income. So you never give money directly to the beneficiary. You pay these accounts. So these third-party trusts, they probably won't be established, or they will be established, but they won't be funded while you're alive. They're usually funded at your death, that if you have certain accounts that going to a beneficiary, you have it going actually to this trust at your death. And that could be the house, it could be your bank accounts, it could be your retirement accounts. That portion for that disabled child should be directed to this trust. Once you pass away, then this trust is funded. You have the trustee that you have appointed in their trust, ready to go to gather the assets and use the money for the benefit of the child. So with that being said, then, you don't want to give money directly to this individual. The way you get around that is with a stable account. So remember I said the stable account has a Medicaid payback provision, and you can only fund it up to $17,000 per year. Well, you could utilize a wholly discretionary trust, a third-party trust, and you could give a lot more financial freedom to your disabled child by utilizing a stable account. And that stable account can be managed by you. You could give a prepaid debit card to the beneficiary, and you could put, increments of money on this card to then pay out, that this child can then use this card to, be a little more, financially free, that they don't have to depend on mom or dad or sibling for that matter, who's the trustee of their trust, that they don't have to go, crawling to their sibling begging for money. No, the sibling can just say, no, I put $5,000 in your card. Go do what you want with that money. That's your money. And if you need more, just let me know. I can put up to $17,000 on this card in a year. So we see that a lot. It's a great tool, but that's what it is. It's a tool. All of these, looking at on the grand scheme of things, a child could have a special needs trust, that could have a stable account, could have a third party trust. Using them together then is the way you can give as much financial freedom to the disabled child as possible. And another nuance to the stable account is you can use a stable account to pay for food and shelter expenses. So you can supplement this beneficiary's life by giving money on the stable account to then pay the rent. And so they have SSI money coming in. That's just more money that they can use on other things. They don't have to spend $914 solely on food and shelter, because the stable account is in the beneficiary's name. It's an exempt account. It's a special account. And they can use this stable account for food and shelter. It's just an extra, nice tool to use to give, much more freedom, a much more respect to our disabled community. So I wanted to touch base on, living independently. Obviously we disabled child might stay with parents for as long as they possibly can. And that's totally okay. I totally understand that. Many clients do that. But during this transition period, we have to start thinking about where is he going, where's our child going to live after we're gone, after we're unable to take care of ourselves. How can we take care of him? What if we pass away? Where is he going to live? You've got to wrestle with these thoughts and talk it over with your attorney, with your support staff at the DD board, with whatever organization that you're working with other family members, to hammer out a plan. But these are just some ideas that a lot of clients utilize. They obviously, you can go with the group home option with the DD board. They don't call them group homes anymore because group homes have a negative connotation nowadays because of prior experiences of what people think of what a group home is. But group homes aren't what they used to be. Obviously, there's bad apples in every walk of life, but they think of it as a rental home now with roommates, and then obviously with provided services to meet the needs of the tenants. But what some parents do, you can buy a house yourselves, or you can join other families or another family to buy a house, and then bring in providers as necessary with the DD board. So basically, you're the owner of the house, not a third party. Other people put in mother-in-law suites, and you really see this. Well, I see it both ways. I see parents building a separate suite for their disabled child just so that they can live it semi independently, but they're really connected to the house. But you also see this with siblings that are now guardian or watching over their disabled sibling, that they build a mother-in-law suite and they use the money that their parents gave them in their third-party trust to build this for them, so they can live somewhat or semi-independently. But there's other housing solutions that have come up over the years, and you think of Medina Creative Housing, or their second property in Ursuline, the Creative Living for Life, and then there's also Solon Community Living. So most of these have different money requirements, either upfront and or over time on a monthly basis. I know Solon Community Living, they're just building now in Solon. They have a unique piece to what they're doing, is they're trying to incorporate caregivers to live at the property in an extra apartment suite that's connected to the building where the adult children would live. So each one has their own nuances, and these are just ideas to have your children live a little bit more independently. So then I just wanted to end our presentation here with an advocacy. The advocate piece to the estate plan, to the transition plan, that we've at Hickman and Lowder, we saw the gap on care, especially after parents pass away or if parents become unable to care for their children as good as they used to because of mental or physical disabilities themselves. So we have a care coordinator at Hickman and Lowder. She's a licensed social worker. she can be incorporated into a trust, let's say, and her role as advocate is to, meet with the beneficiary, meet with the child, and, go over concerns, and is that go between the trustee or the family member and the child and the beneficiary. So, she goes out to visit, once a month, or, once a week or once a year, depending on what the circumstances of this is. But really, where we really see this is if a parent does, have a trust for their disabled child, and the sibling is the trustee. Well, they're not going to be able to, maybe they don't have the time to answer every question or every concern of the beneficiary, or they live out of state. They live in California, which, we have clients that live in California, Florida, New York, and they have their sibling that still lives in Cleveland. The advocate can go check in on the beneficiary, report back to the trustee, and answer any, just being that resource for the beneficiary and for the trustee for that matter, and kind of act as the punching bag between the two. So the trustee can be the trustee and can also be that sibling for that beneficiary. So there's no maybe animosity that might grow over time between the two. So we saw that gap. We incorporated that. Now there's other organizations that are advocates for the disabled and elderly population, but we have that service here at Hickman Lowder. So that's all I've got for you guys today. I'm glad that you guys took the time to come listen to me on a Saturday morning. If I'll wait for a few seconds to see if you guys have any last minute questions. I got one person. Okay, so Jenny, you have a question. You say, so either way, we need a stable account. But a stable account won't hide income. If you have a child who works and earns income of, let's say, $25,000, they may lose benefits. So the stable account is not for income. Income, you got to make sure you think of income and assets differently. All right. Income is what is earned or unearned, and assets is the principal of the account or property that you own. So you can put assets into a stable account, and that will reduce your asset limit to qualify for these needs-based benefits of SSI and Medicaid and the Medicaid waiver. Medicaid, just so, and once again, on a prior presentation, we talked about the ABCs of benefits. Medicaid also has a program called Medicaid for Workers Buy-in program. That is, that $2,000 threshold for assets can actually be increased to over $13,000. I think it's over $14,000 now. But that's for people that are working and they don't qualify for SSI because they're working. So if you have an income of $25,000, I would venture to say that you wouldn't qualify for SSI, and more than likely you probably won't qualify for Medicaid. But if you have $25,000 in income, it might, if you have a family, you might qualify for a different Medicaid program. So it all depends on the circumstances. But stable account is for holding assets, not to receive income. Income is earned or unearned, and it's paid directly to that child. You can't really hide income per se. At what age should we start the process for guardianship? That's an excellent question, and I failed to, point that out. I did point it out for SSI that you start a couple months before in order to start. The guardianship can only be filed at age 18. So prior to that, the court will reject the application because the date of birth is right on top of the application. And if the date of birth says that this child is 17, they will reject it and say, we have no jurisdiction because the parent is the natural guardian. So once that child turns age 18, you will qualify to apply. So I've had clients that actually file that day or that week that the child turns age 18. And I know that you have concerns about that because, yeah, my child is profoundly disabled, can't even talk. What if there's an emergency? If there's an emergency, you can address it at that time, but there's no way of getting that hearing moved up. Remember, I said that hearing is 4 to 6 weeks in advance. There's no way of moving that up, unfortunately. You just have to, it's very rare that an emergency would come up, but I understand the concern that some people might have. But if something does come up, of course, the court's going to address it and make sure that that emergency is being taken care of. Okay, so I don't see any other questions. We do have more presentations in the next coming weeks. I think we have 2 more, and I wish I had that in front of me, but we have 2 more coming up. I really appreciate you guys taking the time. If you have any follow-up questions, feel free to reach out to me. I'll be available by phone or email. I'll be happy to talk to you guys. With that being said, I hope you guys have a great weekend, and hope to hear from you all soon.